My judicial philosophy is straightforward. A judge must be independent and must interpret the law, not make the law.
I welcome everyone to this confirmation hearing on the nomination of Judge Brett Kavanaugh.
Mr. Chairman.
To serve as Associate Justice.
Mr. Chairman, I'd like to be recognized for a question before we proceed.
Regular order,
Mr. Chairman, I'd like to be recognized to ask a question before we proceed. The committee received just last night, less than 15 hours ago, 42,000 pages of documents that we have not had an opportunity to review or read or analyze.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman.
I extend a very warm welcome
to Judge Kavanaugh. We have not been given an opportunity to have a meaningful hearing on this nominee.
Their two daughters.
Mr. Chairman, I agree with my colleague, Senator Harris. Mr. Chairman, we received 42,000 documents that we haven't been able to review last night, and we believe this hearing should be postponed.
I know this is an exciting day for all of you here, and you're rightly proud.
Mr. Chairman, if we cannot be recognized, I move to adjourn.
The American people.
Mr. Chairman, I move to adjourn.
Directly from Judge Kavanaugh later this afternoon.
Mr. Chairman, I move to adjourn. Mr. Chairman, we have been denied real access to the documents we need to advise.
Mr. Chairman, regular order is called for.
Which turns this hearing into a charade and a mockery of our norms.
Well,
and Mr. Chairman, I therefore move to adjourn this hearing.
So here are the facts. Judge Kavanaugh is one of the most distinguished judges. Mr. Chairman, I think we ought to have this.
This wasn't just another Senate hearing. It was the beginning of one of the most politically explosive Supreme Court confirmations in modern American history. Every senator in this room knew the stakes were enormous because a lifetime appointment to the nation's highest court can shape American law for decades.
Loudmouth removed. I mean, we shouldn't have to put up with this kind of stuff.
The reason the Democrats are fighting so loudly on this issue is they're making a demand they know is impossible to meet, and by the way, is utterly irrelevant to what actually Judge Kavanaugh thinks, believes, or has said. It would open up all sorts of fishing expeditions to attack, relitigate George W. Bush's record as president, and what various cabinet members and senior advisors might or might not have said. But it is, at the end of the day, simply an attempt to distract and delay. And indeed, the multiple motions we've seen from Democrats, delay this confirmation, that reveals the whole joke. Their objective is delay. So what is this fight about? If it's not about documents, if it's not about Judge Kavanaugh's credentials, if it's not about his judicial record, what is this fight about? I believe this fight is nothing more and nothing less than an attempt by our Democratic colleagues to relitigate the 2016 presidential election.
And I am telling President Trump, you do some things that drive me crazy, you do some great things. You have never done anything better, in my view, than to pick Gorsuch and Kavanaugh, because you had an opportunity to put well-qualified conservatives on the court, men steeped in the rule of law, who will apply analysis, not politics, to their decision-making, and you knocked it out of the park into my friends on the other side. You can't lose the election and pick judges. If you want to pick judges, you better win.
Last year, you drafted a dissent in Garza v. Hargan, and that's a case where a young woman in Texas, I believe, was seeking an abortion. In that dissent, you argued that even though the young woman had complied with the Texas parental notification law and secured an approval from a judge, she should nonetheless be barred. In making your argument, you ignored and I believe mischaracterized a Supreme Court precedent. You reasoned that Jane Doe should not be unable to exercise her right to choose because she did not have family and friends to make her decision. The argument rewrites Supreme Court precedent, and if adopted, we believe would require courts to determine whether a young woman had a sufficient support network when making her decision, even in cases where she has gone to court. This reason, I believe, demonstrates that you are willing to disregard precedent. And if that's the case, because just saying something's settled law, it really is.
Notice how quickly this hearing shifts from legal qualifications to political warfare. Confirmation hearings are supposed to evaluate a nominee's fitness for the bench, but in reality they often become high-stakes battles over the future direction of the Supreme Court. The interruptions, motions, and heated exchanges are all part of the pressure campaign.
Is it correct law? The impact of overturning Roe is much broader than a woman's right to choose. It's about protecting the most personal decisions we all make from government intrusion. Roe is one in a series of cases that upheld an individual's right to decide who to marry. It's not the government's right. Where to send your children to school, the government can't get involved. What kind of medical care you can receive at the end of life, as well as whether and when to have a family. And I deeply believe that all these cases serve as a bulwark of privacy rights that protect all Americans from over-involvement of the government in their lives. And to me, that's extraordinarily important.
Judge, have you ever discussed Special Counsel Mueller or his investigation with anyone?
Well, it's in the news every day.
Have you discussed it with anyone?
With other judges, I know.
Have you discussed Mueller or his investigation with anyone at Kasowitz, Benson, and Torres, the law firm founded by Mark Kasowitz, President Trump's personal lawyer? Be sure about your answer, sir.
Well, I'm not remembering, but if you have something you want to...
Are you certain you've not had a conversation with anyone at that law firm?
Kasowitz, Benson.
Kasowitz, Benson, and Torres, which is the law firm founded by Mark Kasowitz, who is President Trump's personal lawyer. Have you had any conversation about Robert Mueller or his investigation with anyone at that firm? Yes or no?
Well, is there a person you're talking about?
I'm asking you a very direct question, yes or no?
I need to know I'm not sure I know everyone who works at that law firm.
I don't think you need to. I think you need to know who you talked with. Who'd you talk to?
I don't think I'm not remembering, but I'm happy to be refreshed, or if you want to tell me who you're thinking who works.
Are you saying that with all that you remember, you have an impeccable memory? You've been speaking for almost 8 hours, I think more, with this committee about all sorts of things you remember. How can you not remember whether or not you had a conversation about Robert Mueller or his investigation with anyone at that law firm? This investigation has only been going on for so long, sir. So
right,
please
I'm not sure
Here's where constitutional law takes center stage. The key issue isn't simply whether Judge Kavanaugh agrees with a previous ruling, it's whether he believes courts should follow precedent, a legal principle known as stare decisis. That doctrine promotes stability in the law, but judges sometimes debate when a precedent should be reconsidered. This question goes straight to the heart of judicial philosophy.
Just trying to think, do I know anyone who works at that firm? I might know.
Have you had, that's not my question. My question is, have you had a conversation with anyone at that firm about that investigation? It's a really specific question.
I would like to know the person you're thinking of, because what if there's...
I think you're thinking of someone and you don't want to tell us. Who did you have a conversation with?
I'm not gonna...
Mr. Chairman, I'd like to raise an objection here.
So it seems that you are okay with using race to single out some Americans for extra security measures because they look different, but you're not okay with using race to help promote diversity and equal opportunity and correct for past documented racial inequality.
Sounds like I rejected the racial profiling idea. What's the date of the email, Senator?
The date of the email is January 17th, 2002. And so have you ever suggested or expressed an openness to, even in a temporary circumstance, like this email seems to indicate, in an interim question of using racial profiling? Have you ever suggested that, sir?
I'd like to see the email.
I will provide the email, sir, to you.
But it sounds from what you read like I rejected the concept, but I'll look at the email.
It seemed to me that you were open to the concept, sir, clearly. This is critically important because right now in our nation, there are law enforcement practices, and I think you're aware, that are overwhelmingly target African Americans and other people of color. Yet I've read opinions such as yours in the United States versus Washington that upheld a search, and I quote, in a neighborhood in southeast Washington, D.C. that you called crime-plagued, in Wesley versus District of Columbia, where you would have protected police from liability when they made warrantless arrests at a house that was in, quote, in east of the Anacostia River. You and I both know that those are predominantly black areas.
Yes.
Predominantly African-American communities.
Yes.
I understand there's case law that says police can justify some actions by saying that they were in areas that were high crime. But you know how some of these opinions, using this type of racially coded language, can further the disparate treatment of people of color with the police. And so the way I see it, and I'll give you a chance to respond, is that you're willing to consider using racial profiling and to accept police practices like heavy policing of African American neighborhoods, but you're hostile to the use of race when it is used to promote diversity or remediate past proven discrimination.
Can I get 60 seconds?
Sir, go ahead.
Okay. On the Wesby case, there was a call to the police. It was not the police patrolling the neighborhood. In the Wesby case, the Supreme Court reversed the majority decision that had been written by other people that I had dissented from. They reversed it 9-0 this past term. So what I wrote in Wesby, and I was cited, and the Supreme Court agreed with the approach that I had suggested 9-0. On the general concept, you and I have discussed this in our meeting. I'm very aware of the reality and perception of targeted policing or police activity in minority neighborhoods, and I try as best I can to be aware and understand that, and you and I talked about that, and the Wesby case, in my view, had nothing to do with that issue, and the Supreme Court.
Sir, I try to give you some time there, but this is what I'm hearing right now, sir. And you know, and I appreciate your rhetoric on these matters, but again, you're going to be a judge on the Supreme Court if you are confirmed.
Can you be devout in your faith and still uphold the law?
Sir, my religious beliefs have no relevance to my judging. I judge based on the Constitution and laws of the United States. I take an oath to do that. For 12 years, I've lived up to that oath.
I'm going to release the email about racial profiling, and I understand.
This exchange touches on one of the biggest concerns in judicial confirmations. Can a judge separate personal beliefs from constitutional duty? Every nominee is expected to promise exactly that, but senators press hard because Supreme Court decisions can influence issues ranging from civil rights to executive power for generations. What do you think? Should a judge's personal beliefs ever matter when evaluating their nomination?
That the penalty comes with potential ousting from the Senate. I'm releasing it to expose that, number one, the emails that are being withheld from the public have nothing to do with national security, nothing to jeopardize the sanctity of those ideals that I hold dear.
Running for president is no excuse for violating the rules of the Senate or of the confidentiality of the documents that we are privy to. No senator deserves to sit on this committee or serve in the Senate, in my view, if they decide to be a law unto themselves and willingly flout the rules of the Senate and the determination of confidentiality and classification.
It's called the Presidential Records Act. That's the demon that you're after here. That is the only reason we've got this issue. Now, the custodian of those documents holds and exercises a privilege on behalf of the Bush administration. The custodian of those records has agreed, notwithstanding the privileged nature of those documents, to hand them over to us with an understanding that when there is a need that arises with respect to one or more of those documents to make them public, we can, as a committee, go through a process to do that.
There is no Senate rule that I violated, because there's no Senate rule that accounts for this process. I will say that I did willingly violate the chair's rule on the committee confidential process. I take full responsibility for violating that, sir. And I violate it because I sincerely believe that the public deserves to know this nominee's record.
May I read the Senate Rule 29.5, the standing rules of the Senate, for the benefit of all senators. Any senator, officer, or employee of the Senate who shall disclose the secret or confidential business or proceedings of the Senate, including the business and proceedings of the...
And now the hearing takes another dramatic turn. What began as a debate over documents has evolved into an argument about Senate rules themselves. One side claims transparency demanded disclosure, while the other argues that breaking confidentiality undermines the institution. It's a clash between public accountability and procedural integrity, and neither principle is easy to dismiss.
The committees, subcommittees, and offices of the Senate shall be liable, if a senator, to suffer expulsion from the body, and if an officer or employee to dismissal from the service of the Senate and to punishment or contempt. So I would correct the senator's statement. There is no rule. There is clearly a rule that applies.
Then apply the rule and bring the charges.